Thanks to Justin Trudeau, you're soon going to have a new way to go to prison. Here's how. Simply refuse to use any of these invented gender pronouns anywhere in Canada. Lawyer Jared Brown explains.
For instance, somebody was saying, I'm not going to use those words. That person, if they are dragged before the tribunal,
the Ontario Tribunal,
or the federal tribunal, I've indicated to you already that the Department of Justice has said they're going to pass the same guideline on pronouns. And so what I'm suggesting to you is that if somebody says, I'm not going to use those words, are brought before the tribunal, the federal tribunal, and the tribunal then delivers an order for a payment of a fine and alternatively a non-monetary remedy, i.e. cease and desist order, an order to do something, to compel them to do something. And that person who's brought before the tribunal says, I'm not doing that. They will find themselves in contempt of court, and prison is the likely outcome of that process until they purge the contempt.
So, who is Jared Brown?
I'm a litigator in Toronto. I act in all manner of commercial and employment disputes. I'm not an academic. I live with my clients in the land of legal reality and how the law actually works.
Why is Jared Brown testifying before the Canadian Senate?
About 2 years ago, I began to see claims of discrimination included in every employment-related court claim. My phone now rings weekly with human rights tribunal matters. It has become a reality for employers across Canada. In August of last year, I became aware of Dr. Jordan Peterson. He was discussing what he saw as a problematic law, poorly written. That's when I observed the oddest thing happening. Lawyers, academic lawyers, important people began to say that he had the legal stuff wrong. Nothing unusual about this bill. And they also said, you don't get to go to jail if you breach a human rights tribunal order. What was happening is they weren't defending the law, but downplaying its effects. Now, as a practicing lawyer, anytime a lawyer, and particularly an academic, says, look away, there's nothing to see here, it gets my antenna way up. So I did some research, which can be found in the brief that I filed in advance of today. It sets out the path to prison on this. I knew as a commercial litigator that anyone can end up in jail if you breach a tribunal order. It is a simple civil contempt of court process. People go to jail for this.
Jared Brown is testifying before the Canadian Senate to oppose Bill C-16. This bill is a threat to our freedom of speech. Unfortunately, most Canadians are not aware of it. Here's how you can help change that. First, below this video, there are links to 2 petitions. Sign both of them online. It's easy, and you'll be among tens of thousands of fellow Canadians who feel as you do. Then ask your friends to sign the petitions too. If we stand together, we can hope to defeat this bill. In any case, together, we can make it clear that this bill must be repealed when the Conservatives are elected in 2019. If you wish, pause the video, sign the petitions, and then come back to watch more. Now, Bill C-16 does not actually specify any gender pronouns, so why should we be concerned? Well, after the law is passed, the Department of Justice will fill in the details about how the law will be enforced. They will follow the example of gender pronoun laws that already exist in Ontario. Jared Brown explains.
The problem is that in the Government of Canada Department of Justice website, in their questions and answers section of that website, which was pulled down in December, it makes very clear that the definitions of the terms gender identity and gender expression have already been given by the Ontario Human Rights Commission. The Commission has provided helpful discussion and examples that can offer good practical guidance. The Canadian Human Rights Commission will provide similar guidance on the meaning of these terms in the Canadian Human Rights Act. Now, I take that to be a statement of legislative intent, and I'll agree with you that the bill itself on its face does not seem to imply any manner of compelled speech, but when we're tying it so deliberately and with this expectation, that's where I think you get into some trouble.
But what about the Charter of Rights and Freedoms? Here's Jared Brown's analysis.
But what about the freedom of expression issue? We all know that Section 2B of the Charter sets out that everybody has the fundamental freedoms of thought, belief, opinion, and expression. And we all know that the government has successfully restricted freedom of expression over the years. But what if rather than restricting what you can't say, the government actually mandated what you must say? In other words, instead of legislating that you cannot defame someone, for instance, the government says when you speak about a particular subject, let's say gender, you must use this government-approved set of words and theories. The American jurisprudence clearly defines this as unconstitutional compelled speech. In Canada, the Supreme Court has enunciated the principle that anything that forces someone to express opinions that are not their own is a penalty that is totalitarian and, as such, alien to the tradition of free nations like Canada. Now, how does C-16 get us to compelled speech? The Minister of Justice has summarized Bill C-16 as the enactment amends the Canadian Human Rights Act to add gender identity and gender expression to the list of prohibited grounds of discrimination. The Department of Justice website used to say that we must look to the Ontario Human Rights Commission policies for definitions on these terms. Ontario's policies on gender identity and gender expression are set out in my brief. They state that gender-based harassment can involve refusing to refer to a person by their self-identified name and proper personal pronoun. Refusing to refer to a trans person by their chosen name and a personal pronoun that matches their gender identity will likely be discrimination. If the harasser didn't know or didn't intend to harass, it's still harassment. Now, why is this important? Well, in Ontario, the Human Rights Commission is a policy development creature of the legislature. It creates the policies which interpret the code. But what is most important, the tribunal must follow these policies. It is bound by them. So the Commission creates the law on pronouns. In Ontario, the policies on pronouns were introduced into the legal framework after the law had left the legislature. Federally, the same process will be followed as the Department of Justice had said so. A similar guideline will be developed. As with the Ontario policies, federal guidelines must be followed by the federal tribunal. The guidelines will mandate pronouns. This will happen after the bill leaves the Senate. Mandating use of pronouns requires one to use words that are not their own, which imply a belief in or an agreement with a certain theory on gender. If you try to disavow that theory, you can be brought before the Human Rights Commission for misgendering, or potentially find yourself guilty of a hate crime. To sum up, on the subject of gender, we're going to have government-mandated speech. Now, in opining on the constitutionality of the proposed bill, the Department of Justice said on its website, look, there's a variation of this bill that already exists in most of the provinces. I don't believe that's a robust argument in favor of constitutionality. I would refer you to the comments of the now Chief Justice McLaughlin of the Supreme Court in the decision of Taylor. It's in my brief. The chilling effect of leaving overbroad provisions on the books cannot be ignored. While the chilling effect of human rights legislation is likely to be less significant than that of a criminal prohibition, the vagueness of the law means it may well deter more conduct than can legitimately be targeted. As a lawyer on the ground, I worry about a poorly drafted law and its impact on my clients. As a Canadian, I worry about Parliament tacitly authorizing compelled speech. The brief I provided to the committee contains a comprehensive legal opinion that I published back in December on C-16. There's a table that shows how the federal human rights regime mirrors the Ontario system in terms of enforcement of policies and guidelines.
I have to wrap up, sir.
And finally, it includes the case law that underpins the opinion. Thank you.
Okay, what if you just memorize the new gender pronouns and follow the law? Everything will be okay, right? No, this will affect our freedom of speech and more.
Of particular concern in the area of human rights law is that a lack of clarity will cast a chill on the exercise of the fundamental freedoms such as freedom of expression and religion.
Bill C-16 is a threat to our freedom of speech and a threat to our way of life. So please sign both petitions now, share this video with your friends, and ask them to sign the petition too. Let's act together to defeat this bill now or have it repealed after the Trudeau Liberals are defeated in 2019. Thanks for watching, and thanks for sharing this video with your friends.